Hearing the appeal of Chowdhury Mueen-Uddin against the Secretary of the Home Department.
Mr. Dean.
May it please you, my Lord President, my Lords, I appear with Miss Walker-Parr for the appellant in this matter, Mr. Chowdhury Mueen-Uddin. My learned friend, Mr. Hudson, King's Counsel, appears for the respondent, the Home Secretary, leading Mr. Silverstone and Mr. Stern. My Lords, there is an agreed timetable, which has me speaking until 2:30 today, then Mr. Hudson until 12:15 tomorrow, when I give my reply until 1. Mr. Hudson has kindly agreed that if I can go a little bit over in mine, and it'll come out of my reply. There's a little bit of flexibility at the end. My Lords, this is a very full appeal, as you will have seen in the statements of facts and issues and the full cases. So I will only have the opportunity to highlight a few points from my case orally and to address a few points raised in the respondent's.
You can take it. We've read, obviously, the statement of facts and issues and the parties' written cases, and we've also read the judgments below. So we're pretty familiar with and some of us have read Jamil, and some of us have been over this territory before. So, you know, we're fairly familiar with what the issues are. So don't worry that you might, be short of time.
I'm very obliged, my Lord. My Lord, then with a route map as to, subject to indications from the court as to how I tend to proceed. First, I'll begin with some introductory remarks in 4 sections, namely a summary of our arguments on appeal, a very brief comment about the test for appeal, as your lordships will be very familiar with that, brief observations on the abuse jurisdiction generally, and then a brief observation on the publication which is complained of in this case. My Lords, then I intended to proceed in the order in which the issues are set out in our written case, namely ground 1, which concerns what we've dubbed the full opportunity requirement in Hunter, then ground 3, which concerns the issue of fairness and evidential prejudice within the abuse jurisdiction, then ground 2, which concerns the Dingle case, the question of general bad reputation and the proportionality of the proceedings under the Jamil jurisdiction.
Mm-hmm. I mean, if it helps you, I'm not trying to dissuade you from following that structure, obviously. That's entirely a matter for you. But if it helps you, I think we would benefit from your assistance in analysing Jamil and what really was the ratio of that case. And for the rest, it seems to us that the issue is whether the criteria of Hunter abuse are actually satisfied on the facts here, and just how wide the Jamil doctrine is. Those seem to us, at the moment, to be the central questions.
Well, thank you. My Lords, on ground 4, I hope to be able to make my submissions as they arise in relation to the 3 other grounds, so I may not have anything more to say at the end. And I do hope, my Lord, will agree to make some introductory comments about the Jamil jurisdiction, which I hope will assist when I get to the detail of that under ground 2. Grounds 3 and 2, and indeed the whole test for the court. My Lords, because the issue before the court is whether the courts below were wrong to find that there was a duty on the court to strike out these proceedings as an abuse of the process, whether pursuant to the Hunter abuse jurisdiction or the Jamil abuse jurisdiction, or a form of abuse where those 2 jurisdictions overlapped, as Lord Justice Dingman's put it. My Lords, the consequence of the decisions below is that a British citizen who has lived a full and active life of public and charitable service in this country is denied his right of access to the English court in order to bring a claim for libel against a British government minister over allegations contained in an official Home Office report published to many thousands of people, which stated that he had committed war crimes in Bangladesh in 1971, and that he thereby provides a link between those responsible for the 1971 war crimes and contemporary community leadership in East London. We say the decisions below were wrong because of a series of errors of law, principle and approach by the courts below. First, we say the courts wrongly found the claim was a collateral attack on the 2013 verdict of a Bangladeshi tribunal which had sentenced the appellant to death by hanging. The error arose, we say, because of a failure by the courts below to direct themselves in accordance with the critical requirement of the Hunter abuse jurisdiction, namely whether the claimant had a full opportunity to contest the decision said to be under attack. In our submission, this raises an important point of law concerning the impact on the English judicial process of findings by foreign criminal tribunals which have tried British citizens in absentia on capital charges. Second, my Lords, we say the courts below wrongly found that it would be unfair on the Home Secretary to be required to defend in court the allegations which her department had published. The error arose, we say, from the application of a broad, free-ranging assessment of unfairness, entirely unconnected to the effect of the previous decision said to be under collateral attack, and based purely on the passage of time between the date of publication in 2019 and the events in 1971. We say this test for fairness based on evidential prejudice is not found within either the Hunter or the Jamil abuse jurisdictions, and is not found anywhere else within the common law. This finding of unfairness abuse in our submission has the effect of shifting the abuse jurisdiction away from the established grounds on which it's been developed since the Hunter case in 1964, and detaches it from the important public policies on which it's based. And it opens up a test of evidential prejudice abuse, which, because it's divorced from the effect of a pre-existing prior decision said to be under collateral attack, potentially applies to any case which comes before the court and which requires the investigation of events many years previously. And third, we say the courts were wrong to find that the continuation of the proceedings serves no useful purpose. The error arose primarily from a clear error of law in relation to admissible evidence of bad reputation, contrary to the decision in Dingle, as recently affirmed by the Supreme Court in the Show. And if allowed to stand, the decision on the admissibility of the evidence overturns decades of orthodoxy and throws into turmoil this already highly complicated area of law. And we say this error in relation to admissibility was then compounded by an error in finding that the evidence found to be admissible was, in fact, conclusive on the issue of the appellant's reputation at the date of publication. This resulted from a failure by the courts below to engage in the necessary, close, merits-based analysis of all the circumstances which is dictated by the abuse jurisdiction. And finally, in relation to the Court of Appeal, we say they were led into their various errors by a failure to apply a principled approach to the requirements of Hunter, Jamil and Dingle. In our submission, there appears in the Court of Appeal decision to be an invention of a new form of abuse which is disconnected from and contrary to the established principles. My Lords, then a very brief word on the test of appeal, which will be very familiar to this court. It was most recently summarised by the Court of Appeal in the Municipio de Mariana case. The reference for your note is electronic bundle, page 2501. I don't need you to turn it up. In summary, the position is this. The issue of whether a claim is an abuse is a binary question to which there can only be one correct answer. Therefore, whilst the appellate court will of course be reluctant to interfere where the decision rests on the balancing of a large number of factors, the question for the appellate court is whether the courts below reached the right answer. The appellate court may intervene if it considers the decision below to be wrong by reason of some identifiable flaw in the treatment of the question to be decided, such as a gap in logic, a lack of consistency, a failure to take account of some material factor, or the taking into account of an irrelevant factor, which undermines the cogency of the decision. My Lords, two observations on that test in this case. First, the evaluative exercise by the courts below was not, of course, carried out after a trial, where there would have been voluminous documentary evidence and oral evidence. The court is in as good a position as the courts below to decide what is the right answer. And second, this case does not involve the balancing of a large number of disparate factors. Only 5 factors were identified by Lord Justice Dingemans in his lead judgment in the Court of Appeal, which in reality was only 4 because evidential difficulties were counted twice. And this court is in as good a position as the Court of Appeal to assess whether those factors together require the court to strike out the claim. And my Lords, then to remarks on the abuse jurisdiction. One observation on the abuse jurisdiction in general, which can also be extracted from the Court of Appeal in Municipio de Mariana. It's important to keep in mind at all times, as the court will be fully aware, a claimant's unhindered right of access to justice in respect of a properly arguable claim is a core constitutional right inherent in the rule of law. And the reference is to paragraph 211 of Municipio at page 2518. The abuse jurisdiction is therefore only to be exercised in clear and obvious cases. And in relation to the Jamil jurisdiction, it should only be exercised where the claim can clearly and obviously be seen to be pointless and wasteful. For your note, the other Municipio references are paragraphs 170 to 178, 184 and 188. My Lords, one observation then on the approach to the Jamil jurisdiction, and particularly the approach since the 2013 Defamation Act.
Yes, and do bear in mind that, as far as I'm aware, this is the first time this court has looked at this. And while there may well have been an accretion of authorities in lower courts, don't take it for granted that we're going to follow the same approach.
Oh, yes. My Lords, the court will have noted that there was an application before the respondent, or an application by the respondent before the judge for Part 24 summary judgment, made on the basis that there was no realistic prospect of the appellant successfully proving at trial that he'd suffered serious reputational harm, which is now, since the 2013 Defamation Act, a necessary part of the tort. The judge did not decide that application, and it wasn't renewed by the respondent in the Court of Appeal. In my submission, the claim therefore comes before the court as a claim which is fit for trial on the issue of serious reputational harm, absent the arguments concerning abuse. This is important when considering the Jameel jurisdiction. Jameel was decided before the 2013 Defamation Act in 2005. At that time, libel claims were actionable per se. As the Court of Appeal expressly approved in Jameel itself, there was a presumption of damage in libel claims. There was no need to prove any reputational harm, let alone serious harm, as long as the words complained of had a tendency to cause substantial reputational harm. Now, that had the consequence that trivial claims, which involved no real reputational harm, could succeed at trial. Maybe that there would be a very small or perhaps nominal award of damages, but nevertheless, in order to establish the tort, the claimant did not have to establish serious reputational harm. Jameel was introduced to combat this problem, and the difficulties which were seen to stem from it to the proper application of the court's procedures, taking into account the necessity to give proper time to other claims, and also to balance the rights of the parties before the court, primarily the convention rights to reputation found under Article 8 and the Article 10 right to free expression. So the Jameel jurisdiction, in my submission, presupposes success at trial on the merits of the claim, and the court then proceeds to consider whether, even if the claim had been successful, would it nevertheless have been obviously pointless and wasteful. The claimant could have succeeded where there was no real harm. And in this case, brought as it was in 2020 over a publication in 2019, if the claim were to be successful, then the appellant would necessarily have proved serious harm to his reputation. It would obviously be over the Jameel threshold of harm, which is that there must be some harm which is more than minimal. That's the test which was how it was put by Lord Sumption in the show. Must be more than minimal harm. And in circumstances where there's been no ruling by the court that the claimant, the appellant, has no realistic prospect of success of proving serious reputational harm, and a Part 24 application was made but not pursued, the court should be very cautious about mapping Jameel principles onto what is, ex hypothesi, an arguable claim for compensation for serious reputational harm. You will see observations to this effect from Mr. Justice Warby, as he then was in the Ames case, and the references are given in paragraph 91 of our written case.
Has there been any analysis of the need for a continuation of the Jameel jurisdiction subsequent to the 2013 Act?
Well, the analysis which there is, and it primarily comes from Lord Justice Warby, but it's seen in other cases, not all of which are in the file, is that the primary response by a defendant to a claim which is said not to have caused harm should be a Part 24 application. There's a recognised way of bringing to a halt claims where there is no realistic prospect of success, established within the CPR, and that is to strike out on Part 24 grounds.
Part 24, it's not strike out, is it? It's summary judgment.
Summary judgment, of course. Bringing the claim to a halt for the reason that it could not succeed at trial on the merits. Lord Justice Warby in Ames considers the point as to whether the Jameel jurisdiction still has any role subsequent to the 2013 Act. He says it may do, but it's clearly his view, and the view has been expressed by Mr. Justice Nicklin, the judge currently in charge of the Media and Communications List, that the primary response to this sort of point should be an application for summary judgment.
Do we have the relevant provisions of the 2013 Act anywhere?
Do we? The statutory extracts were at 7. Sorry, that can't be right. What number?
775, my lord.
Page number.
3358.
3358, I'm sorry. Three, 356. Sorry, early on.
On the 2013 Act, don't you?
Yes, Section 1 of the 2013 Act. Do we have that in the file?
I'm sure we do.
No. We can probably find it in the report of Ames.
Sorry, we don't have that in the file. Could you just get the text? Section 1.1 of the 2013 Act, the provision reads as follows: a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant.
Right.
And that's the provision which was considered by this court in the show.
Yep.
The upshot of the decision in the show being that this introduces a requirement to show actual damage. It's not enough that the words would have a propensity to cause reputational damage. The court was quite clear, as a matter of principle, on the facts of the case of the show, that reputational damage can be demonstrated through inference from the nature and seriousness of the allegation which is published, the extent of publication, and the nature and status of the source. It's an obvious matter recognised by the courts that a claimant may find it quite difficult to bring forward actual damage of reputation, particularly in an allegation which is published to all the world. The damage to the reputation sits in the minds of those who read the words.
Yeah.
So there's a threshold of showing serious harm has been caused by evidence, which may be inference from the nature of the words, the extent of publication, the status of the source. Jameel, it's not my submission that there is no room for Jameel post-2013 Act. One can see that there may be room in cases where serious harm may have been caused by the publication complained of, but then has been corrected in some way subsequently. And one can see this in a number of cases, and by way of example, if the defendant had fully retracted the allegation, apologised for it, and it was quite clear that there was no lasting damage to the claimant's reputation, then the need for vindication may fall away, and there is still room in my submission for a finding by the court that the claim would be obviously pointless and wasteful. It may come if there is vindication given to the claimant by a judgment of the court or some remarks by the court in course of a judgment. One can see this, for example, in the Karpov case. Karpov was before the 2013 Act, but the defence, part of the defence of justification was struck out, and Mr. Justice Simon was of the view that there was a very large degree of vindication within his judgment, finding that there was no basis for the defence of justification, as it was then known, or truth, as it would now be known.
It would be helpful for us to know what, in your submission, the principle is that Jamil establishes. I mean, does it establish that any claim can be struck out if it's pointless and wasteful, or that any defamation claim can be so struck out, or is it to do with the absence of serious harm to reputation, or is it to do with the Human Rights Act? Just to give 4 or 5 possible ratios of a case.
Lord, yes. It's clear from the decision in Jamil itself, it has 2 foundations. The first is the civil procedure rules, introduced relatively recently in 2005, which require the court to consider the proportionality of litigation and to keep the balance between litigants before the courts and expenditure on other litigants who may have a claim to bring.
But they can't change substantive law.
Lord, no. And I mean, there's a remark to this effect, almost in this context, in Municipio, that simply because a claim is difficult and expensive to try, that's not a reason to strike it out. The complaint, to remember in that case, was irremediable unmanageability. The Court of Appeal found that was not a basis for proper basis in the substantive law for striking out the claim in that case.
If I buy a kettle at John Lewis and the kettle's defective and John Lewis refused to refund the money I paid and I bring a claim against them, is that to be struck out?
Well, an issue similar to that has been addressed by Mr. Justice Lewison in the case which is not in the file, and I can't immediately remember the name of, but it's a copyright claim, and the question of Jamil abuse arose, and the point being made was that there is, for small claims with a small s, not necessarily in the small claims tract, the court can fashion a proportionate procedure. The question is whether the court can fashion a proportionate
It's not an abuse of process to bring a small claim.
No, because small claims can be dealt with in an appropriate way. So the court is considering, Jamil at its heart is a balance. There's a balance on this limb of Jamil, the use of the court process limb, between the demands on the court process and the potential benefit to the claimant.
One might have thought that Jamil, for example, might be explained in terms of the emphasis placed in the Strasbourg jurisprudence on the importance of freedom of expression, particularly in relation to political issues, and the risks that defamation actions can have a chilling effect on that, in which case there might be a convention-based reason for refusing to entertain cases whose chilling effect was out of all possible proportion to to any possible benefit to the claimant.
My Lord, yes.
And I don't know if, is that what Jamil's about?
That is the second limb. So there are two limbs on which it's based. Neither appears to be given priority within the case of Jamil. They're said to be the twin grounds on which the court can strike out a claim as an abuse. They both involve proportionality. The first limb is balancing the proportionality of bringing a claim where not much can be achieved at great expense. The second limb is a proportionate balance between the convention rights of the parties. And this can be clearly seen in Jamil. The point being this, that reputation is a right found within Article 8. Clear Strasbourg authority to that effect, accepted in the UK. So a claimant in a libel action is seeking to vindicate his Article 8 right to reputation. And it's also, on the other side of the balance, seen to be an interference with Article 10 rights to be sued for libel. Interference with free expression for a claim to be brought against the defendant who has been seeking to exercise their Article 10 right. So that's the second limb. It is firmly based in convention rights. Again, in 2005, the Human Rights Act was relatively new, so the court is applying the relatively new CPR and the relatively new Human Rights Act to a tort which at that time was actionable per se, and there was a perceived problem of trivial claims going all the way to trial at great expense and with great interference to the Article 10 rights of the defendant, where there was very little at stake in relation to the Article 8 rights of the claimant.
One sees that from paragraph 40, I think, page 1943 in the Jamil judgment, where in the first part of the case, the Court of Appeals looking at whether the Human Rights Act has changed the English law of libel as to presumption of damage to reputation. Conclusion, no, it hasn't, but partly, see paragraph 40, that's because there is a different protective mechanism which accommodates the problems of interference with freedom of expression, which is the abuse jurisdiction.
My Lord, yes.
So no need to change the substantive law on Article 10 grounds, because you can accommodate the Article 10 rights through exercise of the procedural power to strike out for abuse of process.
Well, yes, it's a response to the complaint that, as English law stood, it might have been unnecessary interference with the Article 10 rights of a defendant to have to defend a claim where very little was at stake for the Article 8, in relation to the Article 8 rights of the claimant. And the source of Jamil in the HRA is repeatedly being emphasised in the subsequent authorities. And these are set out in our case. Sorry, I'm just finding the relevant paragraph. Yes, it's paragraph 83 of our written case at page 117. We give a series of references to post-2013 Jamil, decisions where Jamil was considered, and quote a passage from Mr. Justice Warby, as he then was, in the 2020 case of Aniyar and McGoldrick, a claim which satisfies the common law threshold of seriousness may still be dismissed as abuse of process if the publication does not cause actual damage which is more than minimal. This is because the court is required by the Human Rights Act 1998 to dismiss a libel claim which was so trivial that its continuation would involve a disproportionate interference with the freedom of expression. So the obligation on the court, the duty to strike out, is found within Section 6 of the HRA.
Yes. Well, again, in Jamil itself, at paragraph 55.
55, yes, my lord.
Page 1947, I mean, the court itself says that.
Yes. So, well, that's right. This is relevant for this case for two primary reasons. The first one is that the problem in Jamil no longer exists in relation to libel claims, because they can only get to trial if there's a realistic case of serious harm having been caused. And secondly, the respondent is a public authority, so has no convention rights to be balanced against the claimant's Article 8 convention right to reputation. In response to that point, the respondent points to the right in Article 10 for the public to receive information, which is, of course, an important right. But that's not what Jamil is about. Jamil is about balancing the situation between litigants before the court.
Well, isn't it generally about balancing Article 8 rights and Article 10 rights? So if there is an Article 10 right in the public to receive information from the government, which there will be, why does that get left out of the balance?
Well, because the twin limbs are proportionality in relation to the court process and proportionality in relation to Article 10. It's about the interference which the claim represents. A claim, there's interference with the Article 10 right of defendant, who some sort of penalty is being sought as a result of exercising the right. There is, in my submission, a case like this, where there's no application for an injunction, because there's no threat to republish. There isn't any relevant interference with the right to receive information. It may come into play if there's an injunction.
I'm sorry, I don't really understand that. I mean, if the effect of being vulnerable to a libel action is that the government doesn't put this sort of information in a report, why is there not, by that means, an interference with the right to receive that information?
Well, my lord, that would occur following success of the proceedings. If the court had determined that the defences failed, so that the defence of truth was not successful.
I'm sorry to interrupt you again, but I mean, in the area of defamation and Article 10 rights, it's not just what happens at the end of the proceedings, one also has regard to the chill effect of the very possibility of bringing a claim. So at some level, the courts have to be able to balance those rights, not just at the end of the proceedings, but have regard to the impact on interference with Article 10 rights arising from whatever the substantive law is that enables someone to sue if information is being put into the public domain.
Yes, but I think I'd accept that. And it's not my submission that Jamil can never have any role against a public authority. But it must have a diminished role when the so it's a human rights jurisdiction. It's based on protecting the right of a litigant. And in this case, where there is no application for an injunction, the right to receive information is essentially one not to, which prevents the state from preventing the dissemination of information to the public. It's not what's been done here. It might also have a role if the reputational damage to the claimant was so low that in reality his or her Article 8 rights were not engaged, and there is a certain threshold of seriousness for Article 8 to be engaged. So it's not my submission that Jamil can never have a role in relation to a public authority. It is my submission that it's an important factor to take into account, particularly where there's a very serious interference with the Article 8 reputation right, and there is no application for an injunction. Because there's no threat by the respondent to republish. There's no indication that the respondent wants to present this information, these allegations, to the public again. My Lords, I'll have a little bit more to say about Jamil when I get to the admissibility of evidence in relation to general bad reputation, because it's an essential part of Jamil. It's the foundation block that there's been no more than minimal harm to reputation. That's how it was put by Lord Sumption in the show.
So your submission is in relation to this balancing under the Human Rights Act and Strasbourg jurisprudence, that it's not a knockout blow to say that in this case the defendant is a public authority, but it is, or it means that there are lower ranked considerations, sort of secondary considerations you might say, in relation to dissemination to the public and so on, that in a case like this are clearly outweighed.
My Lord, yes. Yes. If there's been a balance between rights, on the one side of the balance, there's the public's right to receive information, which I say there's very little interference here because there's no application for an injunction. On the other side of the balance is the Article 8 interference, which is as serious as it could be because there's an allegation of the commission of war crimes.
Was the Lord Justice Lewison case you mentioned, is that Sullivan and Bristol?
It is, it's Sullivan, yes.
It's referred to in the citation of paragraph 14 of your case.
Yes, paragraph 14 of the case at page 48. Sullivan makes the point, which is relevant to my Lord Reed's point about the kettle, that the court cannot strike out a claim for a £50 debt simply because, assessed against the cost of the claim, it's not worth pursuing. Inherent in the value of any legitimate claim is the right to have a legal wrong redressed. So it's a question of fashioning a proportionate procedure in relation to the case. That's the sort of CPR limb.
So what's said in paragraph 44 can't be the whole story.
No.
If the value is £50, the cost of achieving it's £1,000, that isn't, we're told in 45, a ground for strikeout.
My Lord, no. One will have to look carefully at the what the court needs to do on a Jamil assessment is have some idea of what the trial is going to be like. Whether it is going to take, if it were to take 2 weeks of oral evidence to decide the claim for the £50 debt or the claim over the kettle, then we would clearly be in Jamil territory.
Well,
even if
would one? I mean, what's happened to the rule of law? If the seller of the kettle won't refund my money, what am I supposed to do? Just grin and bear it?
Well, Lord, clearly not. I think the response to that from the Court of Appeal in Jamil would be the sort of the twin limb response. The one then comes back to fundamental rights. I should give you the reference in Municipio about the power to strike out not being based upon the case being overly complicated. Perhaps you can... Lord, I'm not here to defend the case of Jamil. Indeed, my submission is it has very little role to play since 2013, because libel claims, which this is, if they can get to trial on their merits, serious reputational harm will have been suffered.
Sorry, what was the reference to municipal you wanted us? Don't worry, come back.
Room 178.
The starting point might seem to be that using the courts to vindicate your rights, if there is no alternative way in which they can be vindicated, is a proper use of the courts, rather than abuse of the courts. And one might think that categorizing proceedings as an abusive process is such a serious step. And as I think you said earlier, one to which there must be a right or a wrong answer, that the court has to be applying clear principles. And at the moment, it's not at all clear to me what the principle is.
My Lord, yes, well, I don't, in my submission, one can't extract a greater principle from Jamil other than the twin grounds which I've set out, based on the CPR and the HRA. It's plainly right that a citizen should be entitled to have access to the court to determine any claim. That is an essential part of the rule of law. The court's control over its own process comes in case management, controlling the amount of evidence which is necessary on the issue. If a party wants to bring 6 witnesses for a week's trial in relation to a kettle, the court could well say no, we can only have 1 witness and they can give evidence for an hour.
Yeah, and you might require parties to attempt mediation. Or if the defendant thought there was a good reason for not paying up, you could put in an offer. And there are various procedural ways of dealing with unmeritorious small claims. And the mediation is a way of trying to divert even meritorious small claims. But to say that they are an abusive process seems surprising.
Well, it's a misuse of the language. Abuse is about misusing the court's process. If you come to court to gain compensation because you've been sold a faulty kettle, it can't possibly be said that you're misusing the court's process in some way. Maybe that's the reason why Jamil abuse doesn't fit particularly well within the abuse jurisdiction. In Hunter, in collateral attack, one can see that is, in relevant cases, a misuse of the court's process. The claimants in Hunter themselves, as acknowledged by Lord Diplock, were not, in fact, seeking financial compensation, but they were seeking a decision of the court to assist in persuading the Home Secretary to let them out on licence. A proper misuse of the process. There's none of that in this case, in my submission.
Was the basis of Jamil that they wouldn't get any substantive remedy?
Well, the facts
of it wasn't worth the candle.
The facts of Jamil were very extreme. There was when the case.
What would they have got at the end if they had got judgment? £1 or something?
They probably would have got nominal damages. In the situation as it was then, there was a claim there was publication to 5 people,
Yes.
3 of whom were in the claimant's camp. So publication of what was a serious allegation to 2 people. In those days, that gave you your cause of action. That was enough. The words met the threshold of the tendency to cause harm. The defences, and it's relevant here, that there wasn't a defence of truth, there was a defence of responsible publication under the Reynolds case, as it was then known, the earlier form of the public interest defence, which is now in the 2013 Act. So the claimant wouldn't have, in fact, got any real vindication from the allegation because the court wouldn't have determined whether it was true or not. The only issue for the court would have been whether the Wall Street Journal had acted responsibly in publishing. So there's a nominal amount of damages and no real vindication because the question of truth is not before the court. And that's what's seen as abusive, seen as a reason not to proceed. And one of the ways the Court of Appeal analysed it was by using the no substantial tort test. Mr. Jamil was not resident within the jurisdiction. He was suing the defendant who was outside the jurisdiction. So he required to get over the various thresholds for service out, including that there's been a substantial tort. In fact, by the time the case got before the Court of Appeal, there'd already been service out, so that wasn't a live issue. Oh, I think it's right that the counsel for the claimant pretty much conceded that if it had been an issue on service out, then he would have had difficulty in getting over the no substantial tort test. So that's one of the ways in which the Court of Appeal, one of which where their analysis derives from. And one sees in the authorities in various places the question of no substantial tort is considered by a court considering a Jamil application. But that was a case involving a foreign claimant suing a foreign defendant. Obviously not the case here, and won't be the case in the vast majority of cases which come before the court. Where in the Jamil case there was a threshold which a claimant had to get over before the court would take jurisdiction. In a case like this, jurisdiction is there because the parties are all within the jurisdiction. I do now have the reference to Municipio, which is pages 2511 to 2512.
Well, just before we go to that, just to pursue this point a little bit further, clearly Jamil was a case of forum shopping by somebody who, in reality, had been defamed in the United States but had no prospect of a successful claim there. And so they're trying to bring a claim instead in this country. And so in order to serve out, there has to be a real and substantial tort committed in this country. And one can readily see why the conclusion was there had been no real and substantial tort committed. Now, the crucial step in the argument really is at paragraph 52, where Mr. Miller submitted that the same principles that applied to real and substantial tort for jurisdictional purposes also applied to a strikeout on the ground of abuse of process. Now, that seems to be the novelty in the case.
Lord, yes, one can see at paragraph 53, the concession which I referred to earlier. Had Dow Jones objected to jurisdictional grounds, England was not the appropriate forum, he might have been hard-pressed to justify exercise of an exorbitant jurisdiction. And so the case had proceeded beyond that question, but very similar principles were mapped onto a claim by a foreign claimant against a foreign defendant. Similar issues still arise in some of the cases, other cases such as Karpov, where again that was probably seen as a forum shopping case.
Sorry, before we move away from Jamil, I mean, there do seem to be strands in the reasoning. I'm looking at paragraph 54, the third sentence, where it's no longer the role of the court to provide a level playing field. Courts concerned to ensure judicial and court resources appropriate and proportionately used. And then paragraph 57 and 58, there seems to be endorsement of statements by Mr. Justice Eady in another case, which seem to have a tendency of, well, if the claim is simply small and it's going to cost a lot to try it, it's not worth a candle, and that's a basis for striking out using the abuse jurisdiction.
My Lord, yes. I mean, that's clearly the approach they're taking. Schellenberg was a Henderson case, and Wallace and Valentine was a case, I think, where the claimant was found to be pursuing a motivated not by desire for vindication, but was pursuing a vendetta. So one can see how that might fit into a proper case of abuse. Schellenberg was a case where the claimant had recently effectively conceded defeat following an 8-week trial on very similar issues against other media organisations, and sought to continue his claim against the BBC.
And this all does get rather bundled up with the human rights aspect. In paragraph 55, the court says, well, there are these two regimes, and they seem to think that it's a little bit unclear to me how they think they work together. But they seem to say that they point in the same direction. But maybe that's going too far with, if you like, the pure abuse doctrine based on the overriding objective, where they seem at some points in the reasoning to be saying, well, if the claim isn't worth the candle, we're just not going to entertain it, even though you've got a good claim, or may do, but we're not going to make the court's processes available to you to vindicate it.
Well, yes, and I mean there's an element of not using the court, that the court has limited resources, and that the court needs to take into account the access of other parties to the court. Again, it's difficult to see how that is a principled approach in accordance with the rule of law.
And also whether the CPR could provide a legal basis for refusing access to the courts to people who, ex hypothesi, have a good cause of action.
Well, yes. It doesn't change the substantive law.
I mean, most of these problems are in practice solved by the creation of the small claims court. I mean, we're talking here about a cause of action that I assume can't be pursued in the small claims court, but most claims can be. I was just wondering whether Jamil has been applied in a non-defamation case, or a case not involving any issue of freedom of speech.
The case of Sullivan, the £50,
Yes.
Or the rest of the £50 claim, is a copyright claim, and one can see it moving out of the free speech zone. In Municipio, it was a claim for damages concerning the collapse of a dam in Brazil and injuries caused as a result. I was going to take you to the reference in that.
Well, there, I think the argument was that it would simply be impossible for the courts to handle. I mean, by the time it was before the Court of Appeal, there was something like 250,000 individual claims. Subsequently, it went up to more than 400,000 individual claims for damages. It was accepted that issues of liability could be tried on a sort of group-wide basis, but it was equally accepted that individual claims for damages would have to be looked at individually in some way or other. And the argument was, well, that's just beyond the capacity of the English court, and that argument was rejected. So it was a sort of, not so much, I mean, in one sense you could call it an abuse, but it was simply, the argument was, well, the court system simply cannot cope with it, and that was rejected.
Yes, I mean, again, it's not an abuse in the central sense.
No, it's not like this sort of case. No. I mean, I was wondering, what about, I mean, trespass to land is actionable per se. You don't have to suffer any damage. Somebody walks across the end of a bit of land that's unfenced that I own. They don't threaten to do it again. I'm not going to seek an injunction. I'm not going to seek a declaration it's my land. Nobody suggests it isn't. But I nonetheless issue proceedings for damages. Now, the maximum damages I might secure in that claim is £1, and I would be very lucky to get as much as that. Would Jamil apply to that sort of case? I mean, it's analogous to defamation pre-2013 because it's actionable per se.
In my submission, Jamil, as a matter of principle it might, but as a matter of practice it probably wouldn't because of the case management aspect.
In what way, then?
Well, one of the problems, again, which Jamil was introduced to meet, was that at that time, before the 2013 Act, libel claims were tried by a judge sitting with a jury. The tribunal, in fact, was a jury. This had at least two implications. The first being it was almost impossible to get summary judgment on any question of fact, because that was a matter for the jury. It's not a realistic prospect test. It's a test whether no jury properly directed could come to the same result. So it's very difficult to apply ordinary summary disposal questions before the 2013 Act. That wouldn't apply in my submission to the trespass case. Libel claims couldn't and still can't be issued in the small claims court, but the court has, I must accept, the powers to case manage and could send a libel claim to the appropriate place. But the trespass case, in my Lord's example, is, in my submission, something which the court could get a proper hold of and hopefully try within a day. The problem which Jamil appeared to be addressing was that it was very difficult to do that with a libel claim, say, because of the presence of a jury, and because one often had a truth defence which involves an awful lot of examination of an awful lot of material. Those problems have now gone. Part 24 summary disposal is available and was tried in this case, and then no decision was made and it wasn't renewed. Libel claims are no longer tried by juries, except in extraordinary circumstances. I don't think there have been any trials, jury trials, since the 2013 Act. So the court's control over the case before trial is now much, it has much more tools at its disposal, one of those being summary disposal. And the question which might arise on the trespass case and should arise on every Jamil case in the libel context is what the trial is going to be like. If indeed it's right to apply this proportionality test between what might be achieved and what's the expense to the public purse and the interference with the Article 10 rights of the defendant in achieving it, one has to have some feel as to what trial is going to be. And that's one of the reasons in my submission why it's difficult, not impossible, but very difficult for a court at an early stage when, in a case like this, there is no pleaded defence, to know quite what a trial would involve. It's part of the Respondent's case and the reasons given by the courts below for striking out as abuse, that there isn't, in fact, much evidence. That's the basis of the evidential prejudice. So the court doesn't really have even have the tools at this stage to determine that CPR balancing test, even if as a matter of substantive law it's appropriate to go down that road.
The most obvious candidate for it would probably be neighbour disputes over a hedge, perhaps, or a foot of land on the boundary. which are quite regularly litigated, ruins one of the parties for what objectively is a trivial potential benefit. And I take it nobody's ever thought that Jamil would apply in that context.
As far as I'm aware, there's no Jamil case in that field, and neighbour disputes are notorious for the amount of money and time spent by the parties and the court on achieving very little important to the parties, but not important to the wider public interest.
Well, I'm not quite sure about that in the case of neighbour disputes, because the alternative, if the courts were not available for neighbours, then there might be violence. So, in a sense, those actions are important in the public interest.
Yes, well, that's the heart of the rule of law. Yes, yes.
The trouble with neighbour disputes is that every day people open the curtains when they get up. They look at the dispute.
Yes. Oh, yes. And just to give the reference to the Court of Appeal in Municipio, because it is the most recent examination in a very different and non-libel concept of non-libel context of Jamil. The paragraph I was thinking of was paragraph 184, beginning at 2511 up to 2512. As my Lord Richard said, the question was unmanageability. You see that at the beginning of 184. And then on 2512, putting that question to one side, unmanageability does not fall with any of the abusive mischiefs identified in the authorities, does not amount to a misuse of the court process in a manner which would be manifestly unfair to the parties, nor would it bring the administration of justice into disrepute amongst right-thinking people. And the Court of Appeal refers to the judge's quotation of Lord Bingham's classic description of abuse in Barker, a use of the court process for a purpose or a way which is significantly different from the ordinary and proper use of the court process. And in my submission, it simply can't be seen that the Kettle case, the trespass case, or, in my submission, a claim over the reputational damage caused by an allegation of being a war criminal can be seen to be a use of the process which is significantly different from the ordinary and proper process. And then perhaps the key point at the end of that paragraph, equally as identified above, the mere fact that the litigation would place a significant burden on the courts could not be an independent basis for a finding of abuse. I mean, that of itself must be right, and I think the traditional way in which the Jamil jurisdiction has been perceived would accommodate that. I think the Court of Appeal in Jamil would have said, well, it can't be enough, but one has to put that into the balance. The question is whether the interference with the claimant's rights justify the burden on the courts. That's the Jamil approach. It is difficult to see grounding for that within the substantive law other than the obligation placed on the court by Section 6 of the Human Rights Act.
In due course, not now. Perhaps we could take a look at Sullivan, because it does seem that Lord Justice Lewison seems to have addressed this sort of problem. So at some convenient point, perhaps it could be provided to the court in case you want to say anything about it.
My Lord, yes. Can I get a copy? My Lord, may I take you to the key document in this case, and I hope it will be the only document which I need to take you to, 3 pages of it, which is the words complained of, which represents what the complaint of the claimant is, where the interference with his rights is founded. This is the report of the Commission for Countering Extremism. We don't have all of the report in the file, but we have the relevant section. It begins at page 706. So can see there what this section of the report is about. It's about what extremism looks like in England and Wales. What extremism looks like in England and Wales now, or at least in 2019 when the report was published. It's not a dry historical work about the events in Bangladesh in 1971. It's about what extremism looks like in this country now. Then to page 733, please. One can see at towards the top of the right-hand column the subheading of the subsection in which the words complained of appear: terrorism and violent extremism. And then the words complained of themselves are at page 736. It's the paragraph at the top right of the main text. We also heard about violence between secular people, etc. A few lines down, the protest was to show support for the conviction of a senior Jamaat-e-Islami leader for war crimes committed during the 1971 War of Independence. And that gives reference to footnote 158. Footnote 158, which is the rest of the words complained of, is at the bottom. The first sentence reads, links between those responsible for the violence in 1971 and JI, that's Jamaat-e-Islami referred to in the main text, in the UK, including community leadership in East London, are well established. And then Mr. Mueen-Uddin is mentioned in the next sentence. So, my lords, this is not simply a report about the conviction. The words expressly adopt and reinforce the finding of the Bangladeshi court by suggesting that not only is Mr. Mueen-Uddin guilty of war crimes, as Mrs. Justice Tipples found at the trial on Meaning, but that he provides one of the links between those responsible for the violence in 1971 and community leadership in London, East London in 2019. It's an allegation about the appellant now in his position of community leadership in East London. And it's important to have that in mind when one is considering the context of the Hunter abuse, about collateral attack, and the context of the Jamil abuse, insofar as the court is entitled to descend into the proportionality exercise. Those are the words of which the claimant seeks, the appellant seeks vindication. It's said to, against me, it's only a footnote, but it's a footnote in an official report produced by a body of the Home Office, published with the imprimatur of the British government. It's a serious report, which will be read by serious people who are interested in what extremism looks like now in England and Wales, and the kind of people who would read footnotes which name those alleged to be responsible for war crimes and thereby provide links between those crimes and current community leadership in East London. We know it was published to over 5,000 people in hard copying by way of download. We don't know how many people also viewed it online. A potentially very large audience, because it was publicised on the Home Office Twitter account, and high-profile individuals who also retweeted it. But it is the kind of report which is likely to sit on the shelves or in the electronic files of those who have a hard copy or downloaded an electronic copy. There's never been any retraction of the allegation by the Home Secretary. Indeed, it's the defendants doubled down on the truth of the allegation by indicating in open court she intends to prove it to be true.
Did they ever explain why they had taken out the footnote? You told us that the relevant passage in the footnote had been removed. Has that been explained in evidence as to why that was done?
My Lord, I think I'm right in saying no. It was removed following the pre-action correspondence.
Yes.
There's
no explanation.
There's no explanation. No, the obvious inference is that well, firstly, there are 2 points. It wasn't seen to be an essential part of this report.
Well, if they haven't given an explanation,
No.
perhaps best not to speculate.
Indeed. But neither was any retraction or apology given when it was removed. There's been no explanation as to why it was included. For example, there's been no explanation how a public interest defence might have worked in relation to this allegation. Lords, I'm now on to ground one. Taking a large amount of my time, but so I'll be brief because the important points about Jamil may arise again. But ground one is in relation to Hunter. It concerns what we've referred to in the written case as the full opportunity requirement. As my Lords will be well aware, that's clearly stated by Lord Diplock in Hunter. It's a well-known passage set out in our case, repeatedly cited and approved in all of the authorities in this area. For your note, it appears in the report at page 1876 of the electronic file. Lord Diplock expressly approved the reasoning of Lord Justice Goff in the Court of Appeal. That's at 1845 for your note. I'll just read out what Lord Justice Goff said. He said that the power to strike out collateral attack abuse arose where a party was seeking, and then these are his words, to raise again a question already judicially decided against him, where he's had a full opportunity of presenting his whole case. So that's where the full opportunity requirement is found. A useful gloss on that was given by Mr. Justice Potter in Smith and Linscalls in first instance, and judgment expressly approved by Sir Thomas Bingham in the Court of Appeal. In Smith and Linscalls, the claimant had been convicted in 1984 of aggravated burglary, and his conviction had been upheld by the Court of Appeal Criminal Division. He then sought in 1990 to sue his solicitors for negligence in relation to the preparation and conduct of his defence. May I pick it up at page 3044, please? Beginning at the paragraph just below G, Mr. Justice Potter records a submission of the counsel for the plaintiff and notes that the full opportunity test was not fully defined or explained in Hunter or indeed in Walpole, which was one of the cases which had been decided pursuant to Hunter by 1995. He says just above J, however, it seems to me that they must refer to something different from the question of whether the defendant was carefully and competently represented or whether he had available to him all the evidence which can later be shown would have been of advantage to him. I say that for the following reasons. And then he says some words in relation to negligence actions where the court is unwilling to divorce a client from the actions of his representatives and to explore the question often years later of whether proper steps or decisions were taken, and if so, whether they would have made any difference to the outcome of a trial. That's one side of the line. And then he talks about the other side of the line on the top of page 3045. On the other hand, the court is willing and able to explore the question of whether, as a matter of law and procedure, a full opportunity was in fact afforded to the defendant, including his advisers, to consider the case against him, challenge witnesses, and present his case. It seems to me that it is in the latter sense that the words full opportunity were used in Hunter and fall to be generally understood in this context. So that was approved by the Court of Appeal in that case.
Sorry, do you have the reference for the Court of Appeal?
Yes, it's... it should be page, it's paragraph 76G, page 3060.
Thank you.
No, sorry, it's all right. 774A of the report. Oh, yes, yes, 3060 at the top. In our judgment, Potter J came to the right conclusion for the right reasons. And they pay an admiring tribute to his judgment. So that's the full opportunity requirement, my lords. Next to why we say it wasn't met in this case, the central point is that the appellant was tried in his absence for his life. It's a basic principle in my submission in English criminal law that a defendant must not be tried in his absence unless the court is satisfied both the defendant has waived his right to attend and that the trial will be fair despite the defendant's absence. We set out these principles at paragraph 51.3 of our case by reference to authority and the criminal procedure rules. So twin requirement of the defendant's waived his right and trial fair in any event. And then in order for a waiver of the right to attend trial to be effective, it must be freely made. The waiver must not be tainted by constraint, as it's put in the cases, and must not run counter to any important public interest. I don't understand any of this to be disputed. The death penalty is, of course, contrary to UK and convention public policy. That's one of the reasons why the appellant could not have been extradited to Bangladesh, had the Bangladeshi authorities ever made such a request. And in my submission, a refusal to attend trial for fear of being executed could not possibly be regarded by an English court, or indeed the ordinary right-thinking British citizen, as a free or effective waiver of the fundamental right to defend oneself at trial. And that point alone in my submission is fatal to any case based on collateral attack. Either the finding of the judge that it was Hunter abuse, or the finding of the Court of Appeal that the fact of the decision was a relevant factor in their overlap, the overlap abuse which they found. It's one of the reasons why the respondents and the courts below's reliance on first instance decisions such as El Dawani in Norway and King and Grundon in New Zealand, nothing to the point, because there's no question of the claimants in those cases having not been able to attend their criminal trials for fear of being executed. We do have a series of other criticisms of the process and procedures of the ICT. I don't intend to take time on those orally. That perhaps
I didn't think they formed part of your ground of appeal. I may be wrong about that. That's still, I'm looking at the statement of facts and issues, and paragraph 61.1, I think, is the relevant ground of appeal.
Well, there's no reference in the ground of appeal, my Lord, to the one point which I just made in relation to not being able to defend himself. Because
That's the point made in your ground of appeal, isn't it?
Well, the point made in the ground of appeal is that
Did not have a full opportunity.
did not have a full opportunity to contest.
And was therefore not within Hunter.
Yes, yes.
I mean, that's the point you've just been making.
It is, my Lord. Yes, sorry, I was just about to say, it's not solely because of the risk of being hanged that he didn't have a full opportunity to contest the proceedings.
I see. You rely, so what else do you rely on?
We make other criticisms of...
Well, I know you did below, but do you in your written case here?
Well, we adopt the criticisms of Lord Justice Phillips.
I see.
Paragraph 72, 74 and 75 of his dissenting judgment. And
Wait, can you just show me in your case where you do that?
Yes.
I mean, I really didn't think that. I mean, I read those words and didn't have a full opportunity as referring to the very points you've been making, rather than, and in any event, it was a wholly unfair process.
Well, that is the prime reason, my Lord, that he couldn't attend for risk of being hanged. The other most important point is that Bangladeshi law disapplied the rules of evidence.
Yes, but and do you deal with that in your written case?
Yes.
Right.
45.
45, right.
The 45 is where we adopt the findings of Lord Justice Phillips. Yes, and at 46, we set out some of the other criticisms. The primary reason he couldn't attend a trial to defend himself was the risk of being executed.
There's quite a lot in your statement, in the agreed statement of facts and issues, about criticisms of shortcomings of the ICT process in terms of fairness. It's paragraph 34 onwards of the SFI.
Lord, yes, there's an important distinction to be made here. It's not our case that the appellant was denied a full opportunity to defend himself before the ICT because of criticisms of impartiality, lack of judicial impartiality, lack of independence, bias. These are the sort of criticisms which are referred to here. It's not our case that's the reason he was denied the full opportunity. Those points come in because they've been very well publicised in the British press and more widely. So they impact upon they're crucially relevant for the impact of publicity in relation to the conviction on the appellant's reputation.
Oh, I see. Right.
That's where these come in. Our complaints about the full opportunity don't rely on establishing a lack of judicial independence. That would offend, or may offend, against the principle of comity, which is relied upon by the respondents. Our points are grounded in simple statements of facts about Bangladeshi law. It was a matter of Bangladeshi law that the penalty, an available sentence for conviction, was death. It was a matter of Bangladeshi law that he could be tried in his absence, and it was a matter of Bangladeshi law that the rules of evidence were disapplied, leading to...
I thought one of the points was that he's defended by a counsel who takes no instructions from him, and he cannot take instructions from him. Is that correct?
My Lord, yes. That's certainly the appellant's understanding of the position.
And you adopt in paragraph 45, last sentence, you adopt in terms the finding of Lord Justice Phillips, or for reasons that he gave in his judgment, that the proceedings fell far short of the standards of fairness recognised both here and internationally.
Lord, yeah, well, that's the point about being tried in his absence without a full and free waiver. So we don't suggest that this court or the courts below properly find a lack of judicial independence. We do say that it's the standard of fairness recognised in this court and international courts requires that a defendant not be tried in his absence unless he's waived the right to attend.
Well, that I follow. I mean, that I completely follow, and that's what I understood to be what ground one was about. And so my question actually is, well, am I right in thinking that is what ground one is about, or is it broader than that?
That is very much at the heart of it and the strongest point. It's slightly broader than that, and we also criticise the. We also say he didn't have a full opportunity to contest the decision because he
couldn't attend because of the risk of execution.
Yes, I mean he also wasn't provided with the usual protections under the English law of evidence. That's the point.
Were you copied in on the correspondence to the court sent by Omnia Strategy LLP?
Lord, yes.
Because they at first were, on behalf, as I understand it, of Bangladesh, were seeking the possibility of intervening in order to meet the criticisms that were being made. But having then looked at what they perceived to be the narrow scope of the grounds, particularly ground one, said that they no longer sought to do so. But were they wrong to read ground one in that way?
No, my lord. I said that it's not. It's a recognition of Bangladeshi law. The Bangladeshi state is perfectly entitled to set up proceedings in this way, perfectly entitled to have a matter of Bangladesh.
Well, I think they wanted to intervene to say that their processes were fair or something of that sort, or alternatively it wasn't an inquiry that this court should engage in. I'm not quite sure what they would have said, but their focus was not on the fact that your client didn't attend for the reasons he's given, but on the fairness or otherwise, as I understand it, of the relevant procedure.
It looks to be like the sort of broader comity point to defend themselves against the well-published complaints about human rights bodies. As I say, that comes in the structure of my submissions in relation to the reputational effect
I understand.
of the conviction.
Okay. But even on that, surely the major point is that it was a conviction reached after a trial at which your client was absent because of the threat of execution.
Well, yes.
So, I mean, look at for that reason, the court in Bangladesh was deprived of the participation of your client.
Yes, I mean,
wouldn't that be the major reason, you would say, for saying that no great weight can be placed on the Bangladeshi conviction?
Yes, at this stage,
it rather dwarfs other points, doesn't it?
It does. I mean, at this stage, one is looking at the effect, the reputational effect, on the ordinary British person hearing about the fact of the conviction, knowing that the appellant had been sentenced to death at a trial in absentia, hadn't been extradited, would, in my submission, very much cause the.
Well, I see the argument.
You have that argument, my lord. That's the central point. But also, as we do set out in the statements of facts and issues in the section my Lord Reed referred to, there was very wide international criticism before and after the conviction about fairness of proceedings and judicial independence.
And this is all set out by Lord Justice Phillips.
Yes.
In his judgment, and he finds as a fact that the proceedings fell far short of our domestic and also international standards of fairness.
Lord, yes.
And I appreciate this may not be a matter of real significance, given that your client was facing the prospect of execution. But But nevertheless, I had taken it from paragraphs 45 and 46 that you were indeed adopting what Justice Phillips had found. Well, in that respect, as well as in relation to the fact that the accused couldn't reasonably the claimant couldn't reasonably be expected to attend the trial because of the likely imposition of a death penalty.
Well, it appeared to us, my Lord, that Lord Justice Phillips was relying upon the matters which I'm relying upon, which is the structure of Bangladeshi law, which he talks about in paragraph 72, and the way in which the structure of Bangladeshi law and the rules of procedure allow the ICT to make findings, for example, findings of fact based on newspaper articles from 1971.
Paragraph 74, he's going wider than that. He's looking at what appears from the ICT judgment and what that says about how actually the process was conducted in the particular case. I mean, I must say, I found myself in the same position as my Lord the President. I had thought that you were positively relying on all of these matters as well. And in paragraph 75, Lord Justice Phillips uses the, if you like, compendious expression, the appellant did not have a full opportunity to defend himself at the ICT, on my reading, to cover both. He couldn't attend, but also look at these matters which I've just been setting out, which are themselves indicative of not having had a full opportunity to defend himself as the trial, in fact, was conducted. Yeah. But have I misunderstood?
No, you haven't misunderstood. The distinction I say is between the allegations of lack of judicial independence and bias and criticisms about the structure of Bangladeshi law and the way it can be seen to have been applied within the decision. That's why I made the reference to the admissibility of hearsay evidence and the way one can see that a newspaper article from 1971 is relied upon for the truth of the proposition that the appellant was the leader of a murderous gang. That, in my submission, doesn't offend the principle of comity, because one can simply, the court can look at the decision itself and come to a view as to whether the court applied processes which meant that even if he'd been able to attend, the appellant would have had a full opportunity to contest the decision.
Well, I think the time has moved on when the courts don't examine. I mean, courts do now regularly examine the fairness of proceedings in foreign courts, so I don't think, not sure comity would really come into it.
No, nor indeed. And in my submission, it's a requirement within the Hunter jurisdiction for the court to do so.
My point was simply what the scope of your appeal was. It wasn't whether this was would have been or was a legitimate issue. Anyway, that was just the reason for my question.
Just to finish the point I was making, it comes out most clearly from the Hamilton and Fired case, where Lord Wolfe said that the full opportunity requirement means that the court must judge the procedural quality of the earlier lists. That case is quite a good example. The earlier decision was said to be under collateral attack was that of the Committee of Standards and Privileges in the House of Commons. It was said by the defendant that the libel claim was a collateral attack on the decisions of the House of Commons. The view of the Court of Appeal, on the basis of Section 9 of the Human Rights Act, was that the court simply couldn't examine the procedural quality of that because the court's not entitled to look into proceedings in Parliament, and therefore Hunter had no role.
Sorry, do you have a page reference for that?
Yes, it's page 1668 of the bundle, page 1582 of the report. It's where Lord Wolfe says that.
Just on full opportunity, I mean, do you rely on what the appellant says in his witness statement, page 304, paragraphs 54 and 58? is the State Council not taking instructions and making limited representations and apparently not being able to take instructions, permitted to take instructions.
I certainly rely on the point that no contact was made to the appellant when he was living in life openly in the UK. State Defence Counsel could have contacted him. It's not completely clear in my submission whether the appellant is correct to say that it was impermissible for the Defence Counsel to take instructions.
But she did not, in fact.
She didn't, in fact. That appears to come from Geoffrey Robertson's report, which is in the file. But I should acknowledge it's not quite clear there what the specific rules were about Defence Counsel being entitled to take instructions. But either she wasn't entitled or she was and she didn't. Final point on this, the propriety of the court looking into the foreign decision. I set out in the case where right across English law one can see foreign decisions are treated differently and with more caution than UK decisions in civil, family and criminal law.
Of course, insofar as comity, if one has to call it that, is sort of floating around in this. This being a strikeout, we have to proceed on the basis that the allegations made by the claimant are true.
I mean, Lord, yes, and there's no a little bit of caution.
I mean, the time for determining whether or not they're true hasn't arrived yet.
Yes. It's no part of the appellant's case that he seeks to establish by these proceedings that he was unfairly tried or the verdict was safely arrived at. That's not his case. That's not his claim. His claim is for vindication of the allegations published in 2019. So it's important to take into account that that's not the purpose of the proceedings. And in my submission, if the defence of truth were in fact to be pleaded and to come to trial, then there's no need for the court to look at the fairness of the proceedings. One simply looks at the evidence which is before the court at the time.
Well, the court couldn't look at the Bangladesh judgment at that point, could it? It wouldn't be admissible.
Well, not for the truth of its contents. The evidence which is recorded may well be admissible.
Oh, well, that's of course that's a different point.
Yes. No, it's certainly not admissible for the truth of its contents. And the point which I've just come to is the related point, is that it's not in a way in which UK convictions would be conclusive proof of that the claimant committed the offence. Section 13 of the Civil Evidence Act expressly applies only to UK convictions. And in my submission, that exemplifies the public policies behind the Hunter jurisdiction. The central point being that the decision of a foreign court does not necessarily, a claim which invites or which might result in a conclusion different to that of a foreign criminal court doesn't necessarily bring the abusive process, the administration of justice in England into disrepute. There's no risk of inconsistent decisions within a coherent system. The principle of finality within a coherent system of civil and criminal justice is not offended. There's no question of English public resources being used twice to consider the same question. And if he's not had the full opportunity to contest the decision, there's no question of, for example, him having a second bite of the cherry, which is the way it's sometimes put. Lord, my lords, I can deal very briefly with the way in which the courts below addressed the Hunter question. Ask you to look, please, at Sir Andrew Nicholls' treatment of the issue at page 238 of the bundle. It's paragraphs 83.4 and 83.7. Sorry. 83, 6 and 7. He proceeds on the basis, as was submitted by the respondent, that the position is the same, even if all the complaints were justified and he was convicted after a gross miscarriage of justice. And then the most operative words in my submission are in the paragraph with Romans 7, beginning about half the way down. However, it seems to me he's trying to have the best of both worlds, by remaining outside Bangladesh but challenging his conviction. In my view, that course is not open to him. The proper forum to decide whether the trial was so tainted by unfairness that the conviction cannot stand is the appellate court in Bangladesh. In my submission, there are three central problems with this approach. First, the judge is approaching the issue as if the purpose of these proceedings is to decide whether the trial was tainted by unfairness. As I've just submitted, that's not the purpose of the proceedings and wouldn't be examined within the proceedings. Secondly, the judge suggests that somehow the appellant had a free choice whether or not to attend the proceedings, and that he's now trying to have the best of both worlds. This, in my submission, in effect, is a finding that he'd freely waived his right to attend. See the reference in the first line of this paragraph. I recognise the claimant was faced with a dilemma. For the reasons I've given in these circumstances, there was no effective waiver whatsoever. There's no dilemma. No rational person could have attended trial in these circumstances. And third, the judge says the appropriate thing for the appellant to have done would have been to appeal his conviction in Bangladesh. But in my submission, it makes no logical or legal sense to suggest that he could have appealed in circumstances where the reasons why he didn't have a full opportunity were those which I just expressed, reasons which were inherent in Bangladeshi law. He couldn't appeal on the grounds that he was tried in his absence, because that's part of the Act which sets up the tribunal. He couldn't appeal on the basis that he'd not effectively waived his right to attend because of the death penalty, because the death penalty is inherent in this aspect of Bangladeshi law. And he couldn't have appealed on the basis of the various criticisms, such as the admission of hearsay evidence, because again, that's provided for by Bangladeshi law. There isn't even any consideration by the judge in this passage as to whether the appellant could have appealed without entering the jurisdiction, without entering Bangladesh itself, and thereby risking immediate arrest and immediate execution. No evidence either way before the court about that. And if it is the respondent's case that an appeal is an answer to this point, then evidence needs to be put before the court as to what that appeal could have amounted to, what the grounds might have been, and how it could have been properly prosecuted.
And also, there's not an examination of whether this could be done now. I mean, if Bangladeshi criminal procedure is anything like ours, if you're going to appeal, you probably have to do it quite quickly, whereas the judge is here seeming to treat the availability of an appeal as almost like an alternative course available to the appellant at this point.
Yes, to be fair to him, my lord, he does address this point in the final sentence of Romans 6, because the submission was certainly made to him, and I don't have the bit of evidence in my head, I'm afraid, that he was out of time to appeal. So the judge accepted maybe the opportunity to do this has now passed. He said that's not material. He didn't appeal at the time.
Right, but I think the point I was trying to drive at is he didn't know he was going to be defamed
Oh,
at the time.
yes.
So, I mean, he's now confronted with a statement about him, which he wishes to challenge. There's a slight tendency of the judge's judgment to read, certainly in 7, as though, well, he has an alternative. An appeal is the right way to challenge that, but it's not available now.
Precisely, my Lord, I adopt that way of putting it. The cause of action here arose in October 2019. That's what sued over, what words were published then. To suggest that somehow the decision about whether to attend trial should have been influenced about whether, if someone were to adopt and reinforce the allegations in a published government report some years later, he wouldn't be able to sue, is simply unreal. And one can see an element of this also in the judgment of Lord Justice Dingemans, where he suggests that the appellant's appropriate course would have been to sue Channel 4 in 1995 over the broadcast which made allegations against him then. It just doesn't recognise that the cause of action which the claimant seeks to bring before the court.
I'm not sure about that, though. I mean, in the sense that if he'd had a perfect opportunity to attend, if the proceedings were perfectly fair, the fact that there's later defamation beyond a time period when you could appeal would be neither here nor there, would it? I mean, if you've had, if you like, a fair conviction where you've had an opportunity to attend, it would be a good argument. Well, if you were going to challenge that, you should have challenged it within the time period given. So it is a separate point, isn't it?
Lord, yes. The administration of justice, Lim, would come into full focus then if there had been a full opportunity in this country. And one can see that, I mean, this is what Section 13 is designed to counteract, where several years later the allegation is an allegation similar to that in relation to which a party was convicted is published, and it rules out a libel claim. But where the judge appears to be taking the view that by this claim he's trying to challenge the original conviction, that doesn't take into account the nature of the cause of action. It's not, for example, the Hunter case or the solicitor's negligence cases where what is complained of is something which happened either before or at the trial, which is under collateral attack. So the proceedings, the complaint about the conduct could and was made in Hunter. In the Smith and Linscall solicitor's negligence type cases, the conduct occurs during the trial where there's said to be the negligent representation. The cause of action is several years previously. Here, the cause of action is 2019.
But Lord Barry's point would apply to foreign criminal proceedings as well, wouldn't it? Like El Douani, for example.
Well, it may apply.
May apply, yes,
now,
I understand.
If either or the limbs of Hunter, administration of justice, and fairness come into play. In El Douani, the fairness limb was at the heart of the judge's decision because it was seen to be a continued harassment of the Norwegian police officer who was involved in the criminal conviction. And also in El Douani, the judge was quite satisfied that the later claimant had a full opportunity to contest the proceedings by examination of the facts. And equally in King, which is the New Zealand case, it's not a Hunter case, but there are elements of Hunter in it. But again, the full opportunity requirement can seem to be to come fully into play. And in those circumstances, the claimant it really is having the second bite of the cherry, one of the administration of justice points. And one has to try and look at it from the attitude of the ordinary right-thinking British citizen. If this has all been gone over carefully in New Zealand or Norway, where the claimants had a chance to bring his appeal all the way, I think his appeal in the King case was, he was refused permission by the Privy Council. So he used all the panoplies of appeal which are available to him. And the right-thinking citizen may well think that there's the administration of justice is brought into disrepute and he has another go in this jurisdiction. But that's not this case. My Lords, may I take you very briefly to the treatment of this issue in the judgment of Lord Justice Dingemans, giving the lead judgment in the Court of Appeal, beginning at page 202, please, which is the reasons section. Paragraph 55 is the contains the finding about the fact of the conviction. It's important to bear in mind before getting to paragraph 55 what he says in 54, namely that the judge is agreeing, so the Lord Justice Dingemans is agreeing with the judge for the reasons he gave.
Sorry, where is that?
Sorry, it's...
That's missed your reference to the
Yes, it's the beginning of paragraph 54.
54, thank you.
In my judgment, in the very particular circumstances of this case, the judge was right to find the proceedings brought Mr. Mueen-Uddin
For the reasons
he gave.
Yes, thank you.
So in my submission, the respectful criticisms I've made of the judge below also infect the decision of the Court of Appeal. The President agreed with Lord Justice Dingemans. The second point is that this paragraph 55, is solely about the fact of the conviction. It's not about the reputational impact. We make a number of detailed criticisms of this paragraph at paragraph 51 of our case, page 108 to 109 for your note. But the overarching point in my submission is that the court simply ducks the crucial question, which must be determined by every court considering a collateral attack abuse application, namely whether the allegedly abusive litigant had a full opportunity to contest the decision. One can see this in the sentence beginning 6 or so lines down with I accept that the fact that Mr. Mueen-Uddin was not able in practice to appear in person before the tribunal impacted on his opportunity to defend himself, as set out at grounds 2 of the appeal. He refers to the point that the Secretary of State was not party to proceedings before the tribunal. He says, these are, however, relevant factors to be considered, but they do not mean that these proceedings cannot be an abusive process. If the appellant's criminal conviction was the only basis for alleging an abusive process, that might not have been sufficient, but it did not stand alone. So, in my submission, my Lords, Lord Justice Dingemans is not making any finding as to whether the Hunter abuse full opportunity test is or is not satisfied. No finding which side of the line identified by Mr. Justice Potter in Smith and Linskell's this case comes. In my submission, that's a crucial step for the court, not only because of clear authority, but also as a matter of logic and common sense. If the claimant did not have a full opportunity to defend himself, full opportunity, then how can this be a collateral attack? Now, it's clear the judge does place some reliance on the fact of the conviction, and, sorry, the Lord Justice Dingemans places some reliance because it's a relevant factor and he's agreed with the decision of the judge. So it appears his view must have been that this was simply some sort of blemish on the proceedings, akin perhaps to solicitor's negligence, or a bit of evidence which had been missed, or which didn't meet the full phosphate sewage test for something which completely changes the nature of the case. Because he places some reliance on it, I say that it seems to be that must be the views taken, which my submissions I've already made, is clearly wrong. But saying it's wholly unclear from what he says. But if alternatively he were saying that the full opportunity was not satisfied, then there's no explanation whatsoever as to how the fact of the conviction can properly play any role in abuse of process. In my submission, my lords, the points I've just been making are the central point in relation to ground 4. Ground 4 is the criticism we adopt and advance, the criticism by Lord Justice Phillips that the overlap approach of the majority of the Court of Appeal was unprincipled, because it seeks to take elements of Hunter abuse and Jamil abuse without finding that either is properly satisfied. And this, in my submission, is the prime example of why that approach leads the Court of Appeal into error. Or Justice Diggerman says in terms, it might not have on its own have been enough. Lords, may I move then to the ground in relation to fairness, which is my third ground of appeal.
So just so I'm absolutely clear, your point or your submission is that if a full opportunity was denied, that is decisive. It doesn't become a relevant factor. It is actually the end of the abuse of process argument.
My Lord, yes. The important principles of public policy fall away. As a matter of authority and as a matter of common sense and logic. Can't be an abusive attack on a previous decision to bring a claim against the court if you've had no proper opportunity to defend the previous decision. It'll arise very rarely in these courts, and particularly in relation to criminal decisions, previous criminal decisions of these courts. There's some criticism made in the Respondent's case of over-reliance on decisions where the prior decision has been a civil one. But it's precisely because of the guarantees given by English law, influenced as it is by the Convention, that ensure an English convicted person has had a full opportunity to contest the conviction, that it's very rarely this will arise. But in my submission, it's as clear as it can be that one is denied a full opportunity to contest a decision if you can't defend yourself without risking your neck, and that no right-thinking person could come to the view that the administration of justice was brought into disrepute as a result of a libel claim making the same allegations. But by making a submission about right-thinking person, I'm making a submission about the administration of justice being brought into disrepute in the eyes of the ordinary person, which is the testing. So, for that reason, the judge's finding about Hunter was wrong, and the Court of Appeal was wrong to agree with the judge and to take this into account as a relevant factor. My Lords, in relation to fairness, there are three stages. There's an error of law in relation to the role of unfairness in the abuse jurisdiction. There's an error of law in relation to the treatment of evidential difficulties more broadly. And then there's the evidence about the lack of evidence in this case. The first point is that in our submission, both of the courts below made a fundamental error of law in not directing themselves that unfairness in the abuse context is the unfairness of being troubled twice by duplicative proceedings. That is the way in which the law in this area was summarised by Lord Justice Simon in the Michael Wilson case. May I ask you to go, please, to page 2441. It's paragraph 48 at the bottom of 2441. The following themes emerge from these cases that are relevant. This is after an extensive review of the authorities in this area in 2017. In cases where there is no res judicata or issue estoppel, the power to strike out a claim for abusive process is founded on two interests: the private interest of a party not to be vexed twice for the same reason, and the public interest of the state in not having issues repeatedly litigated. See Lord Diplock in Hunter, Lord Hoffman in the Arthur J.S. Hall case, Lord Bingham in Johnson and Gore Wood. These interests reflect unfairness to a party on the one hand and the risk of the administration of public justice being brought into disrepute on the other. See again Lord Diplock in Hunter. Both or either interest may be engaged. Lord, I don't detect it being suggested by the respondent that this is not a fair or accurate summary of three House of Lords cases which are referred to. It is suggested by the respondent that fairness, my submission that fairness in the collateral attack context is about being troubled twice, cannot be right, because unfairness abuse may arise where the parties to the later proceedings were not parties to or privies of parties to the earlier proceedings. I quite accept it can arise in those cases, but in my submission that fails to recognise the whole point of the abuse jurisdiction, which is that unfairness in being troubled twice can arise even where the later party was not a party to or privy to a party to the prior claim. The prime example of how this has arisen in the past is in the Tinkler case. The early proceedings in that case had been between the claimant and a company of which he was formerly a director, and the second set of proceedings were brought against the other directors of that company. It was expressly conceded by the directors they were not privies of the company, yet the Court of Appeal found there was abusive unfairness because the claimant was making, in the words of Lord Justice Peter Jackson, in the passage at page 3133 of the file, was making the same essential complaint about the same individuals. So collateral attack abuse is flexible enough to apply where the same party is being troubled twice, even if they weren't parties to the original claim or privies to parties to the original claim. And in my submission, there's no authority for the proposition that the mere fact of a previous decision on the same issue opens up a broad-ranging test of unfairness unconnected to the previous proceedings. As I think I've submitted, the primary limb in these circumstances is the administration of justice limb, because it's rare that unfairness will arise when the collateral attack is said to be on a previous criminal conviction, because the prosecution obviously will have been by the state prosecuting authorities, very unlikely to be involved in the second set of proceedings. It can arise. It arose in Hunter. Lord Justice Goff referred to the fact that the police officers who'd been extensively cross-examined about the alleged assaults on the claimant's both at the voir dire and at trial, were effectively being harassed again by the second set of proceedings brought against them through their chief constable. It arose in El Dawani, as I think I've referred to earlier, where the English claimant was being harassed by, the English defendant was being harassed by continuation of the vendetta against her in Norway. But there's nothing remotely comparable here. There's no suggestion whatsoever that the defendant in this case is in some way being troubled twice, being vexed twice, being harassed by these later proceedings. The unfairness which is complained of is solely based on alleged evidential difficulties which are entirely unrelated to the fact of the previous proceedings. Evidential proceedings in the abuse context are evidential difficulties in the abuse context are generally concerned with the futility of recreating the former trial. That arises in the solicitor's negligence cases, where the problem is authentically recreating what had happened. But that's not an issue which rises here. There's no need for the court to try and recreate what happened in 2013. We've given references in our case of paragraph 71 to serious doubts expressed by Lord Hoffman in Arthur J.S. Hall about whether evidential difficulties can ever be regarded as a reason for declining jurisdiction. And in our submission, he's plainly right about that. There's no principle within English law that a claim may be struck out as an abuse because the defendant would find it difficult establishing a defence he would otherwise like to run because of the passage of time, or that such difficulty can be seen as a relevant factor pointing towards abuse. That is the proposition which is inherent in the decision of both the judge and the Court of Appeal. In fairness, is solely said to relate from the evidential difficulties which the defendant will have in proving the defence of truth about what happened in 1971. And in my submission on analysis, it's quite a radical proposition, because it's not related to unfairness arising out of the previous set of proceedings. It could be applied to any case, whether said to be a collateral attack or not. Apply to any libel claim where an allegation is made about conduct many years previously. There are several examples in the libel courts of that over the years, which are mentioned in the case. And it could imply outside the libel field if the defence of the case of trespass was that this particular route had been used for time immemorial. The defendant says, we'd like to run that case, but we haven't got any evidence. The evidential difficulties of their own are not a reason to try the case. It does arise, of course, sometimes if a limitation period has been missed, or if a claimant has acted some way to delay the case, or to destroy or degrade or conceal evidence, then the role comes for the court to look at evidential difficulties. But on its own, it's not a fact or a reason to refuse jurisdiction. My Lords, we set out in our written case at paragraphs 104 to 111 an analysis of the purported evidential difficulties. I don't propose to take you to that. It's on pages 122 to 123. But the central point of principle is that there's no evidence whatsoever before the court that the respondent would have any more difficulty proving her case now any of the claim had been brought in 2013. That's simply not a question which the respondent has investigated at all. The ICT decision was only 6.5 years before proceedings were issued. Certainly can't be assumed without evidence that evidence which was deployed then is not available now. And so the point of principle which follows the decision is what time does the court judge the evidential fairness is coming from? The courts below went right back to 1971, had great difficulties in proving what actually happened. In my submission, if this aspect of evidential unfairness is to be an element of the abuse jurisdiction, it's got to be connected in some way to the collateral attack. One's got to consider degradation in evidence since the prior decision. Finally, on unfairness, my lords, and this is another aspect of ground 4. This point doesn't appear to be treated as determinative by Lord Justice Dingemans. Indeed, none of the 4 factors appear to be treated as determinative, although one of them is said to be necessary. One can see this from paragraph 65 of his judgment on page 205. Reading from the middle of just about 3.5 lines up. If the Secretary of State or any other person had persisted in publishing the words complained of, he, i.e. the appellant, might be justified in requiring such access today. So he contemplates that the claim wouldn't be an abuse if the defendant or someone else had persisted in publishing the words complained of. But it's impossible to see how that's internally coherent with the rest of the decision. Paragraph 58, on page 204, he said, in my judgment, it will be impossible to obtain a fair hearing of a Secretary of State's defence of justification. If he's right about that, and if he's right that's a reason to refuse jurisdiction, then it'll be impossible to obtain a fair hearing of any claim by the appellant over these allegations, however and by whom they're published, and whether or not there's a threat to republish. The court would not contemplate hearing a claim where it was impossible to have a fair trial. And in my submission, that exposes the problem in this reasoning. It's not in any real sense impossible to have a fair trial. The problem is that because of the passage of time, there may well be not much evidence. And if this is right, that it's impossible to have a fair hearing, then my client, Mr. Mueen-Uddin, here in his 70s, is denied any remedy against anyone who publishes an allegation about what he did in 1971, because it's impossible to have a fair hearing of it. And that, in my submission, is another reason why the Court of Appeal's approach of identifying factors, each of which are said to have some relevance, so it's not quite explained why, but none of them on their own appear to be enough. It just leads them away from the principle. Lords, may I move, please, to what is my second ground of appeal, which I'm coming to third, which is the point about admissibility of evidence of general bad reputation. And this is crucial for the Jamil exercise, whether it's appropriate to do it in relation to the rules of the court or in relation to the obligation by the Human Rights Act because it requires the balancing of the harm which has been caused to the claimant by the tort which is complained of against the interference with the rights of the defendant and or the public more generally if it's the court's processes which are in question. I've got 5 stages to this, which I hope I can get through between now and 2:30. A brief account of the rule in Dingle, demonstrating the error of law made by the majority of the Court of Appeal in relation to the admissibility of earlier press publications, the error of principle of the majority of the Court of Appeal in finding that not only were such prior publications admissible evidence of general bad reputation, but they're in fact in this case conclusive evidence of it. The exception to the rule in Dingle deriving from the case of Goody, which concerns the reputational impact of a prior conviction. A point which is based on the case, sorry, the next one is a point which is based on the case of Karpov about, I think as it's put, given all the other publications which are out there, the suggestion is made that a judgment by this court vindicating the claimant of the allegations against him would have no real impact. And then, if I have a chance, concluding remarks about the approach of the judge and the consequence of the approach of the Court of Appeal. In other words, the principle derived from the case of Dingle is that evidence of previous publications of allegations to the same effect as those complained of in a libel claim is generally inadmissible to prove the claimant had a general bad reputation at the time of publication. It was decided in 1964, but the reasoning in effect was approved by the Supreme Court in the show in 2020. There are a number of qualifications and exceptions. The primary qualification, perhaps, is that if a libel claimant complains of some specific adverse consequence resulting from the publication complained of, then a defendant is entitled to point to other potential causes of that consequence, which may well be other defamatory publications to the same effect. It's necessary to isolate the cause of any specific damage which is complained of, sometimes referred to as the rule in isolation. And that's simply recognition of the usual rules as to causation in tort. It doesn't have any role to play in this case because the appellant, his case on serious harm is inferential. He doesn't rely, for example, on being spat on the street after the 2019 publication. He relies upon the seriousness of the allegation, the extent of publication, and the status of the source. He does rely on some evidence to demonstrate the reach of the publication. He pleads he's been contacted by numerous colleagues and associates who'd read the report and allegations about him contained within it. There's evidence about the reach of the report, but that's not evidence which lets in material about other potential causes. Now, I don't understand that to be, the submission is that the Court of Appeal made a clear error of law, and they made a finding the appellant had a general bad reputation, the date of publication, by reference to inadmissible evidence. I need to spend a little time in the judgments to demonstrate this, as I think what's in dispute between myself and Mr. Hudson is not the principle of law, but what the decision of the judge was, and the decision of Lord Justice Dingemans. If we may begin, please, page 200, paragraph 46 of the judgment of Lord Justice Dingemans. paragraph 46, Lord Justice Dingemans begins with the Karpov case, which I'll address later in my submissions on this topic. He then draws an immediate distinction in the final sentence between the Karpov case, issues about the effect of this publication on the claimant's reputation arise, apart from issues about whether, because of admissible evidence of bad reputation and mitigation of damages, the litigation might not be worth the candle. Then, paragraph 47, some general observations are made about the evidence of general bad reputation. In paragraph 48, the rule in Dingle is addressed. And the error of law in my submission comes in the first two complete sentences on page 201. It said it was noted at page 406 of the report that evidence of a claimant's bad reputation was a grave matter, but that if months had gone by after an uncontradicted report, especially if succeeded by other publications, that could be proved against the claimant. Now, my submission is that Lord Justice Dingemans here is finding that a previously published press report is admissible against the claimant to prove general bad reputation if months had gone by and it was uncontradicted. I don't understand, Mr. Hudson disputes whether that is what was said, but I think it's agreed that if that is what was found, then it was an error of law contrary to Dingle and the orthodoxy ever since. What Mr. Hudson says is that what was the Lord Justice Dingemans was saying could be proved was the evidence of the claimant's bad reputation, not the uncontradicted report. I say that's wrong. One can see that from the next sentence. It's apparent the defendants have been permitted to plead and rely on to mitigate damage unchallenged reports affecting the claimant's reputation in a relevant sector. Lord Justice Dingemans then refers to the rule of isolation, which I say doesn't have any relevance in this case. This dispute about what was being said in my submission is readily resolved in my favour when one looks at the findings which were actually made and the evidence which Lord Justice Dingemans relied upon. Page 203, please, paragraph 56. My Lords, I note the time.
Well, if this is a convenient moment, Mr. Dean.
My Lord, yes.
Very well. We'll adjourn now and resume at 2 o'clock.